Okay, very good evening, students. Good evening, everyone. Very good evening, Prashant, Shivangi, Shivagori. Very good evening. Anyone, please confirm about the voice and the video. Piyush, if you are a first year law student, then I don't think this class is for you because this is basically a mock test of IPC and CrPC. Okay. But if you do want to attend, it's like completely on you. Okay, thank you, Shivangi, for confirming that. On that note, let's begin with this class. So, first of all, I welcome each one of you to my class on the mock test of IPC and CrPC. Let's start with my brief introduction. My name is Sandeep Khatri. These are my areas of specialization. As you can see on the screen, the constitutional law, criminal law, commercial law, family law, jurisprudence, and law of torts. Students, here is the link of my profile on Unacademy. So make sure you follow that to get all the updates about my special classes and my plus courses. Here is the link of my Telegram channel where you can connect with me. If you do have any questions, you may forward your question on my Telegram channel related to your judicial preparation. Here is my code Khatri10 which you can use to get free access of all the special classes available on Unacademy app. So this was about me. I request everyone now please be attentive, and this is going to be an interactive session. So today we are going to do some MCQ questions from CrPC, somewhere around 30 questions on CrPC and 20 questions on IPC. So it is going to be a mixed bag of the test. So I hope you all are ready. On that note, here comes the first MCQ of this class on your screen. Section number 2, when it comes to CrPC, that defined a term victim. And this definition has been given. And now at the end, they are asking victim includes. Choose the most appropriate option out of all the options. One more thing, students, please do write question number before your answer, like 1, and then whatever your answer is, A, B, C, or D. Shivangi, first one to answer B. What about others? Okay, students, now I'm concluding the answer. Basically, B is the correct answer. That is victim's guardian or legal heir. See, this kind of a questions basically challenge that how exactly you can recall the language of the Bayer Act. Okay, so this is basically that. So the correct answer here is B, victim's guardian or legal heir. Moving to the next one. Within the meaning of provisions under section 41C, clause 1 of the CrPC, every state government shall establish a police control room, PCR in. Choose the most appropriate option. First one to answer, Shivangi, followed by Ayush. So the correct answer here is C, every district and at state level. This is again basically challenge your language. See, the point is when it comes to your PT questions, the idea is, whether you can recall the exact language of the provision in your examination hall, yes or no. So basically that is the thing. So C is the correct answer. What is true for the Code of Criminal Procedure? A, it is mainly, though not purely, a procedural law, substantive law, personal law, all of the above. I'll go in the reasoning of the answer as well for this particular question, because there is a concept inside it. First one to answer correctly, Saurav followed by Ayush. A is the correct answer. And Shivangi. Yes, top 3 students to answer correctly. A is the correct answer. Can anyone answer why not purely a procedural law? This is again a very good question for the mains and interview purpose. Why CrPC is not purely a procedural law? Can anyone answer that in the comments? Mir Umar, you have answered B. Substantive law is not an answer. See students, there are two things. The classification can be either procedural or substantive. Procedural means that gives you a procedure. See, the name suggests this. Code of Criminal Procedure, which means CrPC is going to give you a procedure. Like first you need to lodge the FIR, then the investigation will take place. Then after that, the police report will be submitted. After that, the magistrate will take the cognizance. Then the inquiry will take the place. Then the issue of process. And finally, then the trial will take place. So this is basically the procedure. So CrPC is a procedural law, right? But not purely, because yes, there are provisions which gives you a substantive right as well. For example, section number 125, okay, maintenance rights. That's why not purely. Okay, Saurav, wonderful. You have also mentioned section number 125. See, there is a difference between adjective law and procedural law. Okay, Indian Evidence Act is adjective law. Okay, moving to the next question. Which classification of offense comes under CrPC? Okay, top 3 students to answer correctly. First one, Saurav, followed by Ayush and Shivangi. Yes, D is the correct answer. So students, if the question is whether this particular offense is cognizable or non-cognizable, bailable or non-bailable, it's a summon case or it's a warrant case, all this classification comes under CrPC. Classification of offenses given in CrPC under where it is mentioned, the classification of offenses. Top 3 students to answer correctly, Saurav, Ayush and followed by Shivangi. See, the answer lies in schedule 1 of CrPC. There are total 2 schedules, and the first schedule that has 6 columns that will give you whether the offense is bailable or not, by which court that is going to be tried by, okay, cognizable or non-cognizable, bailable, non-bailable. All this information has been given under the first schedule. Now I have one more question to you. If there is an offense under a special law, okay, if there is an offense under special law, for example, an offense under Dowry Act. So if I need to know whether that particular offense is cognizable or non-cognizable, the answer lies in CrPC, yes or not. Please answer in the comments. I hope the question is clear. I'm repeating myself. My question is, if there is an offense which is under any special law, not under IPC, I'm talking about under special law. Now in that particular situation, that, the classification of that particular offense, whether that is cognizable or non-cognizable, that is mentioned under CrPC, yes or no? If yes, where? Okay, I have got my answer. Sunita is the first one to answer correctly. Schedule 1 Part B. So Ayush and Shivangi, please make sure that you go through with that. Okay. When it comes to Schedule 1 of CRPC, that is further divided into two parts. Part A deals with IPC. Part B deals with special laws. Okay. Renuka, you are more than welcome for that. New batches are going to start recently. ठीक है जी, there are batches which are started on almost every 15 days, so you can easily join that. ठीक है. At the end of the class, I'll tell you the courses as well, which are going to be which are going to start recently. Okay. Okay. I hope everyone is clear with this one. Now moving forward to the next question. In a cognizable case under IPC, the police has the, choose the most appropriate option, authority to arrest a person without warrant, authority to investigate the offense without permission, C both A and B, D either A or B. रेनिको, अगर आपका कोई स्पेसिफिक क्वेश्चन है तो यू मे आस्क और यू मे फॉरवर्ड योर क्वेश्चन ऑन माय टेलीग्राम चैनल एज वेल. ओके. Okay, top 3 students to answer correctly. First one, Saurav, followed by Sunita and Shivangi. Top 3 students to answer correctly. And yes, C is the correct answer. When it comes to cognizable offense, the police has all the authority to arrest without warrant and even investigate without the permission of the magistrate. Okay, so the correct answer is both A and B. Who has the power to declare any area metropolitan areas? High Court, State Government, Central Government, Court of Session. Please do mention the relevant section number as well. Please do mention the relevant section number as well in the comments for this answer. Okay, perfect. Top 3 students to answer correctly, Saurabh, followed by Sunita and Ayush. Yes, B is the correct answer, students. It's the state government that is going to decide, whether this is going to be any metropolitan area or not. There is one specific condition as well. If you can write in the comments, there is a minimum number of population. So if you can tell that, if you can tell me that as well in the comments. Yes, what is that? Minimum population for metropolitan areas. That is again mentioned in section 8. Okay, 1 million and 10 lakh both are the correct answer. But make sure if you are writing this in the mains examination, make sure use the word 1 million. Reason being that is the term that has been used in the Bail Act. Next one. A magistrate has the power to direct the police to investigate into an offense in IPC under, choose the most appropriate option. Saurav, Sunita and Deep, top 3 students to answer correctly. Yes, section 156 clause 3 is the correct answer, where magistrate has all the powers to direct the police officer to investigate into an offense. Okay. Okay, let me go into the details of this question. There is one interesting question here, students. Everyone, please do participate, okay? So the question here is, suppose FIR has been lodged. So it means it is a case of section 154. We are dealing with cognizable offense if I am using this term that FIR has already been lodged, okay? Now my question to all of you is, when FIR has been lodged, first option, is it the discretion of the police officer to investigate or not? Or second, it is mandatory for the police officer that he has no other option but to investigate in that case. What will you choose? It is the discretion of the police officer to investigate, after lodging the FIR, or it is the discretion of the police officer. Mandatory or discretion when it comes to investigation after lodging the FIR. Yes, please do answer in the comments. Okay, first one to answer, Shiv Gauri, it is mandatory. Ayush is also saying mandatory. Okay. Deep is also saying mandatory. Can anyone tell me why you are saying mandatory? If you can refer any particular section or anything, any case law for that matter. Because if you are saying it is mandatory, you might have read somewhere. So any section number or any case law for the reference. Okay, Sunita, first one to say discretion. Sunita, same counter question to you as well. If you are saying it is the discretion of the police officer, if you can tell me the exact section number where it is written. Sagar is saying mandatory. No, Shivagori, we are not talking about case diary. That is completely a different concept. We are not dealing with the case diary as of now. Okay, mandatory you are saying. Okay, now let me answer, students. See, the answer is, okay, anyone writing the reasons? Should I wait or conclude the answer? I think I should conclude the answer. Okay. Now, listen carefully. So the answer is, it is not mandatory. It is the discretion of the police officer. Mind it, students. Lodging of FIR, if the information is of cognizable offense, that is mandatory. But to do investigation is something which is complete discretion of the police officer. Now coming to the reasons, sir, where it is written, you may refer section 156 clause 2. So basically section 156 talks about the investigation in case of FIR. Right? So when it comes to section 156 clause 2, it specifically uses the word may. And what do we mean by that, this term may? May means maybe, maybe not. So it is basically the discretion of the police officer. But if under section 156 clause 3, if a magistrate is directing the police, you have to investigate in this particular offense, then the police officer has no discretion. Then obviously, as per to section 156.3, the police officer is bound to investigate because the orders come straight from the magistrate. I hope everyone is clear with this. If yes, quickly give me a thumbs up. I'll move to the next one. And if you still have any doubts, you may write your questions in the comments. Chaliye ji. Done? Okay, perfect. Next one. Now, in a non-cognizable case under IPC, the police have the authority. Choose the most appropriate option. Okay, first one to answer correctly, Sunita, followed by Ayush. Students, C is the correct answer. We are basically talking about non-cognizable case here. So in the case of non-cognizable, the Whether the police officer has the power to investigate without the order of magistrate? The answer is no. Whether the police officer can arrest? The answer is again no. And if your answer is incorrect, please do refer section 155 for this one. Okay. An order of life imprisonment may be passed by. Who may pass this order? So basically we are talking about the power. The power of the session judge or magistrates we are talking about. Who may order the life imprisonment? I think the easy one, you should not take much time for this one. Saurav, Shivagori and Sagar, top 3 students to answer correctly. Simple one, easy one, that is none other than session judge. Judicial magistrate second class can pass sentence up to. Write down the section number as well for this particular one. Which one is the relevant section number to answer this question? First one to answer correctly, Ayush, followed by Sunita. Okay, we are talking about judicial magistrate second class. So the maximum sentence he can give up to 1 year. So C is the correct answer. Okay. It is mandatory for the police officer to inform the person arrested the grounds of arrest and right of bail if the offense is not non-bailable under. So basically this is talking about the duties of a police officer while making the arrest. Here we are talking about the section number. Okay, Sunita has mentioned the correct section as well for the previous question, that is section number 29. Okay. Shivagori, that's why I use the term be attentive. This is basically the direct question. If you can recall the section number, you can easily answer this one. Deep, Sunita and Sagar, top 3 students to answer correctly, and that is B. Section number 50 deals with this one. This is basically the duty of the police officer. Okay. No woman shall be arrested after sunset and before sunrise except obtain prior permission from. Which means the general rule is that after sunset and before sunrise, the woman shall not be arrested. But if there are any exceptional circumstances, and if the police officer have to make the arrest between this timeline, then he needs to take a prior permission from whom? Choose the most appropriate option. First one to answer correctly, Shivagori, followed by Deep and Sunita. I think easiest question you can think of. Section number 46 you can refer here, which is basically judicial magistrate first class. If the proclaimed person does not appear within the time specified in the proclamation, the property under attachment, choose the most appropriate option out of all these. Okay, I hope you can read all the options easily. Okay, question number 14. Students, a humble request again, please do mention, the question number as well before your answer. Okay. So the first one to answer correctly, Shivagori, followed by Deep and Ayush. Okay. So yes, A is the correct answer. That is of 6 months. So see, the logic is very, very simple. The reason is so that, within 6 months you can come, and if you want to claim, you can claim for the property. Period of appearance for proclamation issued under section 82 is not less than. So the minimum time period which we have to give for basically the proclaimed offender. So the time period is going to be Sunita, Deep, and Ayush. Ayush, you have answered C and B both. Okay. So B is the correct answer. That is not less than 30 days. It is mandatory to produce the person arrested before the magistrate within 24 hours of his arrest under which section? I have some questions attached to this concept, so I'll discuss one by one all the questions. Okay, so the first question is basically the section number they are asking about. So tell me the section number. One of the most famous section you can think of. Shivagori, Sunita, and Deep, top 3 students to answer correctly, and yes, D is correct one, 57. Now, my second question related to this one is that whether the time of journey will be included in the 24 hours or excluded from this 24 hours. So the time of journey from, for example, from the place that person got arrested to the place we are taking to the police station. So the journey, the time of the journey will be included in this 24 hours or excluded from this 24 hours. First one to answer, Deep, excluded. Sunita, excluded. Okay, everyone's answer is correct. Now coming to the last question related to this concept. Can you please tell me why do we have this provision that, after arrest within 24 hours, we have to present that person, before magistrate? Why do we have this provision? What is the objective of this provision? Yes, what is the objective of section 57? Anyone, if you can tell me in the comments. What is the objective which we want to achieve through section 57 of CrPC? Okay, Ayush has answered police brutality avoidance, to protect from illegal detention, constitutional right, article 21. Okay, to some extent, I think everyone's answer is correct. So let me put it in a precise manner. So the answer to this question is, students, that, the whole chapter of arrest, starting from section 41 till section number 60A, that this whole chapter includes, duties of the police officer, rights of the arrested person. Okay. So for the purpose of section 57 is that the magistrate will make sure that the duties has been performed, that was a legal arrest, and whosoever has been arrested, he has got all the rights. So to ensure all this, whatever we have written here, so to make sure that this has been implied as well, okay, all the duties has been performed, the rights has been used by the arrested person. So for that purpose, we do have section 57. Okay, moving to the next one. Minimum monthly maintenance under section 125 is, minimum monthly maintenance under section 125 is, Ayush, sir, police is very brutal. It will beat the accused black and blue and make him or her confess or admit things he or she will never committed. Okay, Ayush, first thing first, the world is not so bad. Okay, see, there are incidences where things like these has been taken place. We do have a landmark judgment of DK Basu as well. But, as a judicial aspirant, you should have a positive approach towards all the all the organs of the government, right? So done. And let me tell you this as well. I should state this as well, which is again from my personal experience. Things have been completely changed. Okay, it is, we are not living in that era no more, where if just because if there is a police officer, he can do anything. Okay, there are exceptions. Okay, I'm not saying everything is good, everything is perfect. There is always a room for improvement. But yes, we are in very much living in matlab like safe zone. Okay, chaliye. Okay, Sunita, Shivagori, Deep, everyone's answer is D, and that is correct one, students. There is no minimum, there is no maximum limit. And the reason is again very, very simple, because the amount of maintenance depends upon family to family. It depends upon the status of the family. So if there is a poor family, there might be maintenance of 10,000 rupees per month, and at the same time the maintenance amount for the second family may go to 10 lakh per month. So that again depends upon family to family, status of the family basically. When a complaint is presented to a magistrate and the magistrate proceeds to examine the complainant and the witnesses, choose the most appropriate option. Okay, top 3 students to answer correctly is Deep, Arathe, and Ayush. Yes, B is the correct answer. Done. So basically, when it comes to, a complaint is presented before a magistrate, and while the magistrate is examining the complainant, so basically we are talking about section number 201 here. So 201 is not, trial. It is not, it can never be investigation, because investigation is done by the police officer. So I don't think anyone has written A, but you might get confused with option number C, but the correct answer is B. Okay, I hope everyone knows the reasoning as well of the answer now. Maximum period an accused to be kept in police custody by the executive magistrate. Shivgori, I hope now it is clear, the previous question. If you can mention the section number as well, where it is written. Sunita, first one to answer correctly, followed by Arathi Lakshmi and Ayush. Deep, how can you miss this? Deep and Shiv Gauri, I'm asking about executive magistrate. Deep and Shiv Gauri. Okay. So it's 167. Classification of summons case and warrant case. Why this is important? Why it is important to know whether this case is a summon case or a warrant case? What difference it will make? So on that note, choose the most appropriate option. Top 3 students to answer correctly. First one, Shivagori, followed by Jayant and Ayush. And everyone's answer is correct. The answer is A. To determine the trial procedure, right? But when it comes to investigation, that makes no difference. Ordinary place of trial is ordinary place, which means in a general rule, as a general rule, which is the place of trial. Ayush, Shivagori and Arathi Lakshmi, top 3 students to answer correctly. A. Everyone's answer is A. So you all know that where the offense has been committed. And if you can tell me the section number as well for this concept. Just tell me the section number as well and I'll move to the next question. Come on. Bahut badhiya. You know, this in this whole chapter of jurisdiction, the first section, that is 177, is a general rule. And from 178 till 189, all are basically the exceptions of this rule. Mostly all are the exceptions. Who may take cognizance under section 190? Okay, top 3 students to answer correctly. Arathi Lakshmi, first one to answer correctly, followed by Jayant and Shivagori. Okay, so who may take cognizance? The correct answer is Judicial Magistrate first class. Okay, Judicial Magistrate second class may take the cognizance only if that magistrate is authorized by Chief CJM. Okay, so that's why JMSC is not the correct answer, or CJM under section 190. So C is the correct one. Complaint proceedings under section. The term complaint has been defined under section. Do write down. Then the complaint proceedings I have already asked. Top 3 students to answer correctly. Sunita, followed by, okay, only one student. Only one student has answered correctly. Students, section 204 is issue of process. Yaad aa gaya? Section 204 is issue of process. So the answer is going to be from section 200 till 203. Okay. 200 is examination. Then 202 is postponement. 203 is discharge. There are only 4 sections involved. The maximum term of imprisonment awarded in summary trial is. Read the question carefully, everyone. Top 3 students to answer correctly. First one Mohit, followed by Sunita and Jayant. D is the correct answer, students. That is the 3 months. The maximum term of imprisonment. See, the reason is again very simple. When it comes to summary trial, which means as the name suggests, the trial is not going to be long. It is going to be short. Why? Because of the kind of offenses that has been involved. So for that matter, you cannot give imprisonment to someone more than 3 months. Right of an accused for plea bargaining in India relates to first one to answer correctly. Okay. Rathi Lakshmi, first one to answer correctly, C, followed by Sunita and Ayush. Okay, so C is the correct answer. See, when it comes to plea bargaining is of 3 types. In plea, you can bargain about the facts of the case. Okay, you can bargain that. Charge bargaining, you can bargain on the charges. Okay, just remove these particular charges. Okay, and then the sentence bargaining is basically you are bargaining about the punishment. So when it comes to in India, we are basically do sentence bargaining, not the fact nor the charge. Under CrPC, cognizance can be taken of offense, accused, witnesses, offenders. Okay, first one, Ayush, charge bargaining is basically if there are 3 to 4 charges that has been put upon that person. Okay, like for example, the charge of 302, the punishment for murder. So 302 is basically the charge. Okay, so if there are 3 to 4 charges that has been applied to that person, so in charge bargaining that person is I'm okay with these 2 to 3 charges, so you can take off this particular one. Now coming to this question number 26, first one to answer correctly, Sunita, followed by Arathi and Shivgori. A, yes, A is the correct answer. Always do remember, cognizance is always taken of the offense, that this particular offense has taken place, not about the witnesses or the accused. Which of the following requirements need not to be followed under section 200? Ayush, I think we have to cross-check this one. I think in US. I'm again not sure about this. You may Google that. But in US maybe. And yes, there are going to be countries where charge is also bargained. Or even fact. Top 3 students to answer correctly, Arathe, Deep and Ayush. Yes, everyone's answer is correct. That is C. When it comes to examination of the complainant under section 201, there is no need of the accused. There is no role of accused there, right? So accused must be given an opportunity to heard. That has nothing to do with section 200. Okay, that is examination of complainant. If the offense is punishable with fine only, then the period of limitation for taking cognizance is. I have some additional questions as well for this particular question. First, you answer this one and do write the section number as well. The section number of this particular question is very, very famous and has been asked in your exams repeatedly, I would say. Top 3 students to answer correctly: Sunita, followed by Mohit and Shivagori. Deep and Jayant, 3 months is not the correct answer. 6 months it is. ठीक है जी, please refer section 468. Okay, now I have one more question. When it comes to Limitation Act applies to offenses or not? The Limitation Act applies to offenses, yes or no? Answer in the comments. Mohit, first one to okay. Deep, first one to answer no. Mohit, no. Sunita, no. Okay, everyone's answer is correct. Yes, Limitation Act has nothing to do with the offenses. But yes, when it comes to CRPC, we do have a separate chapter, that is chapter number 36, which we are going to talk about, where we do have some provisions that is going to deal with the limitation period. Okay. Filing of FIR is a condition precedent to the exercise of the power under section 438 CrPC. False, true, partly correct, none of these. First one to answer, Mohit, followed by Sunita and Shivagori. A is the correct answer. That is false statement. Okay, there is no condition precedent that you have. There need to be lodging of FIR. That is not a condition precedent. The condition precedent is that there is apprehension of arrest in a non-bailable offense. That is the condition precedent. Now we have some questions from the IPC. Which of the following is an offense out of all these? Shivagori, Mohit and Arathe, top 3 students to answer correctly. D is the correct answer. Okay, can anyone tell me what is the difference between B and C? Mind it, it's a very, very important question. What is the difference between option number B and option number C? What is the difference? Make sure you apply all your judicial mind on that. What is the difference between B and C option? B, 300 exceptions. Intention. Okay. Anyone else wants to try? C is 299. There is none. I guess they can be reciprocally used. C is covered under 299. B is basically all the 5 exceptions to section 300. Okay. Students, option number C is culpable homicide, right? Which is section 299. Culpable homicide not amounting to murder is again culpable homicide. So there is no difference between these two terms. Okay, and if in case if your defense is ki sir, the exceptions of section as you have written that exceptions of section 300 will fall under B, then what about section 299 clause 2 and 299 clause 3? Basically there are no clauses, but to understand the concept we say that, for example, intention to cause bodily injury which is likely to cause death. So that is culpable homicide not amounting to murder, right? So there is no difference. There is no difference between the term murder and culpable homicide amounting to murder. Okay, I hope now it's clear. Okay, the one thing at least you can take away from this class is this one, right? At least, and there can be many, by the way, for that matter of fact. But yes, this is, I think, going to be the very, very important one. Are you sure answer is correct? Okay, fine, happy. Your answer is correct. I hope only you have written the correct answer. Done? Chaliye ji. Moving to the next one. Now be quick, these are very, very easy questions. How many circumstances has been enumerated under section 300 of IPC under which culpable homicide is murder? How many circumstances where culpable homicide is murder? Please answer. Indirectly, they are asking how many clauses are there in section 300. So the answer is 4. Everyone's answer is correct. Okay, Arati Lakshmi 5. No, there are only 4 clauses to section 300. 300 firstly, secondly, thirdly, and fourthly. That's it. There is no 300 fifthly. There are 5 exceptions, by the way, which has nothing to do with this question. A fires on crowd with no reason. As a result, B dies. What offense has A committed? Fires on crowd. Deep, Sunita and Mohit, top 3 students to answer correctly. Murder is the correct answer. It's a case of murder. If you are firing on the crowd, you have intention to kill. That's it. 301. A on provocation by B kills C, B's child. A can be charged for. That's a very, very good question. Basically, it's not a question, it's one of those questions which is basically have those, what we call that, for the fumbling in the words. अरे क्या बात है. Everyone's answer is correct. Starting from Sunita, Shivgauri, Mohit, everyone has written C. Murder is the correct answer. Intention of causing death is not essential under section 300 clause. Is there any clause under section 300 where intention of causing death is not essential? Students, please confirm about the voice. Are there any issues with the voice? Voice check 1 2 3. Voice check 1 2 3. Yes, D is the correct answer. Mohit, first one to answer correctly, followed by Advocate Bhavna and Sunita. D, C is not the correct answer. Okay. Fourth is the correct answer because here we are talking about basically the knowledge. See students, if there is an echo, so I don't think I have much options. If you can like avoid that, please do. Okay. This was an easy one. I don't know why you are answering incorrect. Okay, whatsoever the reason is. Top three students to answer correctly. Arathi Lakshmi, first one to answer correctly, followed by Sunita and Ayush. Okay, so this is basically explanation 1 of section 299. Okay, explanation 1 of section 299. Doctrine of transfer of malice under section. Sunita, Shivgauri, and Mohit. Everyone's answer is correct. That is 301. KM Nanavati versus State of Maharashtra is a leading case on. This is a landmark judgment. The last judgment where jury was involved. Grave and sudden provocation. Correct answer. Ayush, Sunita, and Amrupali Bhattacharya. Correct answer C. The plea of sudden and grave provocation under section 300, exception 1 is a top three students to answer correctly. Arathi Lakshmi, Advocate Bhavna, Shivgauri. Yes, C is the correct answer. That is completely a question of fact, whether it is a plea of sudden and grave provocation. नहीं, ये उल्टा लिखा है. Grave and sudden provocation होगा ना, sudden and grave थोड़ी ना होगा. उल्टा लिखा है क्वेश्चन में. Grave and sudden provocation. One of the most repeated questions in your exams. Most repeated questions in your exams. And yes, Shivagauri, Sunita, and Ayush, top three students to answer correctly. This is the correct answer is culpable homicide amounting to murder. Distinction between section 299 and 300. Which case law gives distinction between section 299 and 300? Top three students to answer correctly. Okay, there is only one, by the way, who has answered this question correctly, and that is Ayush. Students, R versus Govinda is, talks about difference between these two sections, but State of AP versus Punaya is also a landmark judgment on the same matter. So the answer is going to be both A and B. C is going to be the correct answer. Okay, so please do update your notes. Mention this case law, and this is not just another case law. Let me tell you this as well. It's a landmark judgment. Death penalty should be awarded in rarest of the rare case. You should not take much time while answering these questions. Bachchan Singh versus State of Punjab is the correct answer. Gyan Kaur versus State of Punjab. Sunita and Ayush, correct answer. This is attempt to commit suicide. Sham Bihari versus State of UP. Sham Bihari versus State of UP. I have not received the answer till now. Okay, no one has read Sham Bihari case. Sham Bihari is basically Dakati with murder. So the correct answer is going to be D, Dakati. Sarla Mudgul versus Union of India. Ayush, Sarla Mudgil is on bigamy, not adultery. It's on bigamy. ये तो मतलब सभी को पता होना चाहिए. जोसेफ शाइन वर्सेस यूनियन ऑफ इंडिया. And that is basically 497. Saroj, this is not 377, 497. Adultery. Lakshmi versus Union of India. On this case law, there is a famous movie as well, Lakshmi versus Union of India. D. Ayush, Varsha, Ayush, Sunita. D is the correct answer. Subramaniam Swamy versus Union of India. मूवी का नाम सभी को पता है. हाँ? Yes, Chapak is the movie. Yes, that's a landmark judgment on defamation. Mittu versus State of Punjab. Landmark judgment again, 303. Last question, students. Navtej Singh Zohar versus Union of India. and that is unnatural offenses. So anything now which you are not clear with, you may ask. Students, this is the link of my profile, my Telegram channel, and this is my code Khatri10. Let's crack PCS J with Unacademy. I have an important information to share with all of you. That is, if you are preparing for your judiciary examination and you are doing it, by yourself, so this is the opportunity for you. Just enroll yourself for this particular test. You don't need to pay any kind of fees. The test is completely free, and if you are going to score good, you will get 100% scholarship for your Unacademy subscription. If you are rank 1, you will get a tablet. For rank 2, there is a 5G smartphone. For rank 3 to 7, there are earbuds. For rank 8 to 17, there are home speakers. And for rank 18 to 100, there are gift vouchers available. Which means this is a win-win situation for you. You are preparing for your judiciary examination, and if you are going to do good and do well in this examination, there are gifts attached to it. There are 100% scholarship available for you. Okay, so the test will take place on 13th of November at 11 a.m. Okay, so just make sure that you do good in this test. There are the syllabus for this test is basically all your major laws like CPC, IPC, evidence, CrPC, and so on. Okay, so that is the syllabus for this examination. Anything else? Ayush, the next session I have already shared the complete timetable on my Telegram channel. You are going to have YouTube session on 29th, 30th, and 31st. And in all these sessions, we are going to cover all the MCQ questions of different subjects as well. What subject I am going to deal with? I have already shared all the information on my Telegram channel. All you need to do is just open your Telegram app. In the search bar, search for my name, Sandeep, Sandeep. My surname starts with K, so that's why there is a K, and UA is for Unacademy. And you will reach to my Telegram channel where you can find. I have already pinned the complete schedule of YouTube sessions. Okay. सरोज सर, अगर कोई फैमिली मेम्बर गर्ल को कंपेल करता है मैरिज के लिए तो वो क्या सेक्शन 366 में आ सकता है? सेक्शन 366 सरोज, दैट डिपेंड्स कि कंपेल कर कौन रहा है. ओके, if there is a family member doing it, and by family member you mean the father or the mother, so they cannot abduct their children or they cannot kidnap the children. Okay. See, there are, Saroj, I am just assuming by your question that this is a practical situation. So for that matter, there are various factors which we need to see. That even if there are parents who are forcing the girl to get into a marriage, so there are provisions available. But then again, I'll suggest you better consult with an advocate and just tell all tell all the problems. Okay. Chaliye ji. On that note, thank you very much. See you in my next class. Till then, yes, it's time to say peace.